Hello, my name is Rebecca Chen and I'm a partner with Reddy Newman Brown PC in Houston, Texas. Today we'll be going over the difference between requesting a change of status versus consular processing in your H-1B CAP subject application. We'll go over the risks and the benefits associated with each, and we'll be focusing specifically on H-1B beneficiaries who are in the U.S. right now in F1 status and are working for their H-1B petitioner using their OPT employment authorization. So if you are in this category and you were lucky enough to be selected in the March lottery and your H-1B petitioner is now preparing the I-129 petition to be filed by June 30th, if they select change of status on the I-129 form, what that means is that as long as you remain in the U.S. between the time the petition is filed and September 30th, your status will change automatically from F1 to H-1B on October 1st. This is assuming that the H-1B petition is approved by October 1st and your employer has listed October 1st as the start date for the H-1B validity period. There are some situations where it could be later if the petition is pending beyond October 1st, for example, or if they have listed a later start date, then your H-1B status will go into effect on the date listed on the I-94 that is attached to your I-797 approval notice. So this is really the most straightforward way to get into H-1B status. It doesn't require you to depart the US or apply for a visa from a consulate. It just changes automatically to H-1B on October 1st as long as you are within the US. So given that it is very straightforward to change your status to H-1B within the US, why would some applicants choose to do consular processing when they have the option of change of status? So for F1 OPT workers, usually if they opt for consular processing, it's because they want to prolong the period of their F1 OPT employment for a couple of reasons. And the reason why their F1 OPT employment period can be prolonged is that if your application is approved with a consular processing request, your I-797 approval notice will not have the I-94 attachment. Your status does not automatically change to H-1B by remaining in the US. You have to take that approval notice, go to a consulate outside the US, go through the visa interview, get the H-1B visa stamped in your passport, and then re-enter the US in order to start your H-1B status. So it requires more steps, but gives you more control over when your H-1B status starts, and it in turn allows you to remain in F1 OPT status longer. And there are a couple of reasons people opt to prolong their F1 OPT employment. One is if your H-1B was selected relatively early in your OPT employment and you have 1 or more years of OPT employment left. Some people want to use up as much of their OPT as possible before jumping into H-1B status to give them sort of more of a runway to undergo the permanent I-140 process before they hit their H-1B 6-year limit. Another reason is financial. So F1 OPT employees are not subject to the FICA tax withholdings. That's the Social Security and Medicare withholdings that most US workers have withheld from their paycheck. So H-1B workers are considered residents for tax purposes. So once you move over to H-1B status, you start having those tax withholdings withheld from your paycheck. And so some F1 OPT employees want to maximize their period of income that is not taxed. And so they want to stay in F1 OPT status as long as possible. So those are some of the benefits, but there are significant risks associated with opting for consular processing that people should be aware of. One crucial risk is associated with job loss. So the main risk really is if you are at risk of being laid off or terminated from your H-1B employer. The reason for that is because when you postpone the start date of your H-1B status, you are also postponing being counted against the cap. So most people actually are not aware that if you're selected in the lottery and you have an I-797 approval notice, those alone are not enough to be considered counted against the H-1B numerical limit. The regulations are pretty clear that one of two things needs to happen in addition to those. Either you have to have gotten the H-1B visa issued to you by a consulate, or you were granted H-1B status within the US. So if neither of those things have happened, even if you have an H-1B approval notice, if you then get laid off by your employer, you basically lose the benefit of that lottery selection because it's too late at that point to go for visa stamping. You won't be able to get the visa stamp when you no longer have that job offer that's described in the approved H-1B petition. There's no way to change your H-1B to a different employer because the cap selection is not transferable to another H-1B employer. You basically have to find a new employer who will register you in the lottery the following March and get selected again, which of course is never guaranteed. And so that insecurity of not being locked in with your cap selection is basically the biggest risk with opting for consular processing. Alternatively, if you opted for a change of status and your status changed to H-1B automatically on October 1st, even if you are laid off after that, you have more options. So even if you were laid off October 2nd, as long as you were in H-1B status for at least one day, if you lose your job the next day, you get the benefit of the 60-day grace period that attaches to all H-1B workers. And you can have your H-1B application transfer filed to another employer without ever having to undergo the lottery ever again. So that is really the main benefit with going with a change of status is moving over to H-1B and locking in your cap selection as soon as possible. In our opinion, that security really outweighs any benefits associated with a prolonged period in F1 OPT employment. We hope this was helpful, and if you have any further questions or would like to discuss your situation further, we encourage you to make a consultation with me or any of the other attorneys in our office. Thank you.